Head of the Litigation Department at Tarlow, Breed, Hart, and Rogers. Hi, Mark.
Hi, Jeffrey. Great to be with you this evening.
Nice to be with you, too. Mark, what's on the litigation agenda today?
Well, I wanted to talk about a case decided that comes out of a sale of a business. Here it happened to be a veterinary practice, but the story is one that applies to business sales in general. So it's an important thing for business owners to be aware of. So in this particular case, the seller operated a veterinary practice, and what made it particularly valuable was it had one of the few licenses to handle radioactive material that was used to treat cats who suffered from serious illness. And so seller makes a decision to sell the practice. A buyer's very interested in it, but I think the particular value was this license to be transferred. A very substantial piece of the business came from this radioactive treatments. So a bunch of agreements get signed. An asset purchase agreement, very common. There's a cash payment of $800,000. There's a $400,000 promissory note payable over a number of years, very common. There's an employment agreement for the seller. In this case, it was at will. Frequently in the sale of businesses, it'll be for a fixed amount of time because the buyer wants a transition payment. There was a non-compete agreement, very common, a non-solicitation agreement that prohibited soliciting clients or impair the goodwill of the business once the seller sold the business. And there was an agreement with a lab that was involved with these, that did these lab tests, which were a reliable source of payments to the seller. And under the agreement, those payments after the sale would be continued to be paid to the seller, but this time by the buyer. Seller owned the building and retained ownership of the building. They had a trial, and the jury, there was evidence from which the jury could find that the seller acted in bad faith, unfairly, deceptively, and never intended to allow the buyer to get the lucrative radiation treatment income, but instead had a plan to recapture it for herself. And so after the sale, she secretly, while working for the buyer, made a deal with a third-party company to open a radiation treatment center for that new company in a different location, but outside the non-compete range, which was 30 miles. She then submitted false documents claiming that she was the owner and she was moving her practice to a new location and connecting with these new folks. She sent out an announcement to the practice's referral base, falsely stating that its treatment center, the practice's treatment center, was relocating at this third party's place of business. And she allowed a similar misrepresentation to be included on the third party's website.